Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today, we are talking about how to approach settlement for a child custody establishment case. So what we're looking at here is a case where you don't have any custody papers in place, you've never been married, but you have a child in common, and you want to get court orders in place for legal decision-making, parenting time, and child support. And there's two ways to approach this. You can just file the papers, serve the other side, and move your case forward that way. Or before you file, you can make a settlement offer. And so that's what we're going to talk about today is if you have sufficient information and you're ready, this is one way to approach your case, is to try to just resolve it from the outset and then file papers with the court on an agreed upon basis. All right, so we are going to start by talking about how you're going to take your case strategy, put that into a settlement offer, share the settlement offer with the other side, engage in negotiations. If you're able to reach an agreement, then you'd put that agreement into a stipulated order and then take the proper steps to lodge that stipulated order with the court. So the first step is to create your strategy. If you haven't done that yet, go back to the prior videos and put together a legal decision-making, parenting time, and child support case strategy. So for legal decision-making, are you requesting sole or joint decision-making? And is that on all of the issues? Are you wanting to name a final decision maker? Go back to those videos and all of your options are laid out there. For parenting time, what is your year-long proposed parenting plan? For child support, what is the proposed amount of child support you are proposing to pay or that you're proposing the other side pay? What is your proposal to divide uncovered medical expenses? Who are you proposing will provide medical insurance for the minor children you have in common? And what is your proposal to divide the child tax exemptions? So that's all going to be your positions, which are your case strategy, and then that's going to go into your settlement offer. So first get clear about what you're asking for. And then take those points, put it into a written offer. If you're just going to discuss this with the other side, there's a good chance that there could be a miscommunication. So putting it in writing really helps make it clear as to exactly what you're proposing. Be sure to include an offer deadline. It doesn't necessarily have to be set in stone. You can be flexible with the deadline, but the point is to keep moving the conversation forward. If you don't have a deadline, then your offer could just languish and nothing's really happening. But if you have a deadline in there, that can help to move things forward. And then when you're ready, share your written offer with the opposing party and be ready to start negotiating. So when you are putting your settlement offer into writing, into this letter, be cognizant of the words you're using. Be polite. It's harder to get an agreement in place if you're sending a really mean and nasty letter. Be clear and concise. Add as much detail as possible to make sure it's very clear what your position is and what you're requesting. Explain your next steps if no agreement is reached. So, putting in your offer deadline and then explaining that if they don't respond to you by the deadline, then you intend to file papers with the court and serve them with them and move the case forward through the court. So including that deadline is important to keep moving things forward. It's nice when you write this letter if you keep it organized. So explaining, hey, this is my offer. I want to get court papers to establish custody. Here's my offer. Here's my offer for legal decision-making. Here's my parenting plan proposal. Here's my child support offer. And, keeping it very organized in your letter is helpful. Once you've written your settlement offer, you need to convey it to your co-parent. You can do that by email, text, mail, and/or hand delivery. It's nice if you can send it by email because then you have proof that you sent it. It's not that you necessarily are going to need to show proof to the court, but if there's any sort of question about whether or not it was actually sent, you do have, you should have a record of that in your email. But overall, I would confirm the opposing party received it. Of course, if you're hand delivering it, it's clear they've received it. And then you can confirm the opposing party is aware of the response deadline you put in your offer, just to keep the communication going and try to keep making progress. Once you've conveyed the offer, now be open to negotiating. Sure, it's nice if the other side just accepts your proposal in full. However, it doesn't always happen that way. It's often, a give and take. So be ready to negotiate. And also when you're drafting your settlement letter, you can keep in mind that there may be some points to negotiate and factor that in to your offer. Now, what if the opposing party doesn't respond? What if you don't get to engage in negotiations because they're just not even communicating with you? Number one, confirm they received your offer. So make sure there isn't some communication breakdown. Also, if they respond and they just say no, you don't have to give up at no or a non-response. Consider asking the other side to specifically identify what about your offer they object to, because that can start the negotiations going. And then you can remind your co-parent that if they won't negotiate with you, then you're going to proceed with filing papers with the court. So sometimes that is effective at getting the other side to come to the negotiating table if they don't want to get stuck in a long, potentially drawn out court battle. Now, what if you are negotiating, but you reach an impasse? Well, I encourage you to look at the big picture. Are there any, what is your request? What's the other side's request? How far apart are you? How close are you? Are you willing to negotiate on this point and maybe agree to the other side's position just to get the deal done? So looking at the big picture and seeing if there's any room to be flexible. Really assessing your case. Is it worth taking the point that's in dispute to a judge? Is your position on that point that's in dispute a very strong position? So really assessing your case and seeing if it's worthwhile to dig your heels in, or if maybe you need to be a little more flexible and reach an agreement. Get creative. Maybe there's this one place where you're at an impasse and there's another place where you're in agreement, but you're able to do some sort of trade-off or sweeten the deal on the thing you're in agreement with to get what you want on this other point that's in dispute. So again, try to look at the big picture, get creative, and see if there's any way you can get this deal done. Also consider requesting mediation. There's private mediators, there's mediators through the court. Sometimes getting a neutral third party involved can help you, see the big picture, assess your case, get creative, and resolve an impasse. Now, if you've reached an agreement, what do you do next? Well, you're going to take the terms of that agreement on legal decision-making, your year-long parenting plan, and your child support, and you're going to put that into what's called an establishment order. So an order that is establishing decision-making, parenting time, and child support. Now, paternity could also be a factor in this. If the father is not named on your child's birth certificate, or paternity hasn't been established any other way. So that could be another part of your agreed upon order. And then with your order, there's two parts to it. There's the findings, and then there's the orders. So when you have this template for the proposed stipulated order, first you'd work on drafting the findings, then you work on drafting the orders based on your agreement. Once you have it drafted, you would share the proposed stipulated order with the opposing party to see if they have any objections. And again, ask them to respond to you by a certain deadline to keep moving things forward. Once you have this final stipulated order that both of you have agreed to, then you're both going to sign it in front of a notary, and then you can lodge it with the court, meaning you can e-file it with the court. When you lodge it with the court, you're going to mail or email a copy to the opposing party as well. So again, once you have this final agreement, both sides have agreed to all the language in the stipulated order, both sides sign it, then it gets filed with the court, provide a copy to the other side, and then when the judge signs it, your agreement is in place. It's a final order of the court. Okay, so a summary of what we talked about today. To approach settlement before filing to establish custody, create your case strategy on legal decision-making, parenting time, and child support. Make a written settlement offer with a deadline. Engage in negotiations. And then if you reach an agreement, you'll need to draft a stipulated order to establish legal decision-making, parenting time, and child support. Paternity would also be a factor in that, or a part of that, if paternity hasn't already been established for your children. And then you'll e-file that proposed stipulated order, which both of you have signed before a notary, with the court. And once the judge signs it, your case is resolved, and legal decision-making, parenting time, child support, potentially paternity, all of that will be established at that point. All right. Thank you so much for joining me today. If you have any questions, please join me at our live Q&A sessions.